estate plan itself, a will, a trust, those things work for the benefit of the survivors, of your heirs.
Yeah.
But what people overlook just doing it, they don't do it or they put it off. And, it's not an engine light. There's no engine light. If something's wrong with your car, the engine light's going to come on and say, you need to do this, you need to do this. Estate planning is something that people don't get warned about until something horrible happens, and then they wish they would have done it. So the other thing they forget about is estate planning is more than just planning for your death. It's more than just thinking about when I die, what's going to happen to all my assets. It's more than that. It is planning for your incapacity. So if you're incapacitated, somebody still has to pay your bills. You have people who you want. We're living in the age of HIPAA. Which is the Health Information Portability and Accountability Act. Right? That's that little waiver, that little privacy notice you sign when you go to the doctor, saying we won't give your health information to anyone. But not giving that health information to anyone also means if you're in an accident at midnight on a Saturday night and your spouse can't find you, then you might not be told by the nurse's station that you're there at the hospital, right? Or if you have an out-of-state family member who calls a nurse's station and knows that you've been in an accident and wants information just to find out if you're there, if you're okay, they can't do that because you don't have a HIPAA waiver on file with that person's name on it. So there are fundamental documents that can help you if you're incapacitated or you're injured. Somebody has to pay your bills. So if you're incapacitated, so you need a general durable power of attorney. Thinking about incapacity, what would happen if I were in the hospital for a week or a month and I needed someone to take care of my life? If you don't have an estate plan with a focus on incapacity, you don't have anybody who can do that because there are no legal documents authorizing that.
Man, that's
no.
Go ahead.
No, that's the second mistake is don't just think about it as planning for death. Think about it as planning for your life. Incapacity.
One of the things I say, Stephanie, is death is easy. It's incapacity that's the issue, and yet it's incapacity gets overlooked all the time because everyone's focused on death. If this happens, estate planning, my estate does X, Y, Z. And I always say, but what if you're not dead? What if you're incapacitated? Like you gave the perfect example as people like, well, my wife's a beneficiary. I said, man, but you're not dead. We just established you're not dead.
She doesn't get anything. Yeah,
exactly. What happens? So that's what else jumps out at you?
Well, the other thing that jumps out at me, and I'll give you an example, is some people use tools like payable on death accounts as like we call it kind of the poor man's estate plan. They'll either do joint tenancy with right of survivorship with their spouse, or they'll do a payable on death account and have that paid off to a relative or an heir that they want their money to go to, and then they think that's enough. But what about everything that isn't in that pay upon death account? And I'll give you, here's a story. And this is a story about my father-in-law, really. My father-in-law passed away in North Carolina a couple of years ago. He had most of his money in a pay on death account to a step-grandchild, right? The money had come from his wife anyway, her life insurance or something. So he thought it was best to pass to the step-grandchild. The problem is, he had other assets outside of that account, like houses and cars and tangible personal property, his furniture and all of his household goods and a gun and all this other stuff that were not taken care of, and he didn't have a will. Now, who's responsible? His biological children. His heirs, his biological heirs, are now responsible for the estate, although all of the money in the estate, the cash, is going pay on death immediately to a step-grandchild, right? So $100 and something thousand goes to the step-grandchild. Now the biological children are stuck settling the estate and paying the attorney for probate, and I'll talk about probate in a second, but paying the attorney for probate some $6,000 while all the money is sitting in an account that is gone to a step-grandchild who now grabs the money. He's due the money. It's his money now. Takes the money and goes and doesn't. There's no help with the estate because there's no money to pay the attorney until you settle all of the assets. So of course now your biological children who didn't get that pay on death account, didn't get any of the bank accounts, now have to lay out money of their own until they settle the entire estate, which, was quite nominal, by the way. Maybe enough
Right.
to pay the
Oh,
attorney a
that's
little bit more.
crazy. Yeah.
So when you die intestate, so in the state of Georgia, for instance, if you die intestate, your estate goes through what they call probate process. And it's essentially a legal process where the court oversees your estate closing, the closing of your estate and how the money is distributed. So it's a required process. So, and what we like to say about the probate process is that it's essentially a lawsuit that you file against yourself, with your own money, because now you have to pay an attorney like me to go to the probate court,
right,
and help dispose of your assets. And a personal representative has to run around. It's quite a hassle. The personal representative has to get your death certificate. That could take a month to get a death certificate. And if there's a mistake on it, it could take 3 months to fix. By the way, that recently happened to a client of mine. So, the probate process can be quite long. It can be quite short if you have a small estate in the state of Georgia. You can get out of it. But you're going through a court process when you could have avoided it through proper estate planning, say with a living trust.
Yeah.
So
that's crazy. That I can only imagine the biological children are like, man, we're stuck with all this. There's not going to be enough. I mean, it might be enough just to make us, even Steven, but that kid's already, spending the money on friggin' beer and cigarettes. You know what I'm saying? And
22-year-old, you're gone. You're going to party, right? Or whatever you do. And also this was in North Carolina, and neither child lived there. So then you have to hire a probate attorney. Somebody has to clean out the house. Somebody has to pay for all of that, or you just walk away. But you don't want to just walk away. You want to try to, there are sentimental things in the house.
Yeah, that's what I'm saying. Just walking away. I mean, you got stuff in there that's probably your own from when you were a kid. Oh, that's nuts. Exactly.
That's so it's tough. And that's the kind of thing that can happen because, he thought everything would be just taken care of, I guess,
right.
And maybe didn't think about it at all, but it was actually quite complex. It took about 12 months to settle that estate, and that was not a huge estate. It just wasn't. And so people say all the time, I don't really have that much. I just need a simple will. Can I just go online and get a $50 will or something? And the fact is that's not the case. That's not true, because you don't realize the total value of your assets. Number one, that's another mistake people make, is they don't know the value of their assets or where everything is, right? They don't have a list of where all of their accounts are, where all of their assets are, where all their liabilities lie. And, not knowing that means that the person who gets your estate at the end, your personal representative or your family member who has to deal with all of this, or even an attorney like me who's dealing with the probate issue, we have to try to figure out where all your assets are and where your life insurance is, and hope that, we get it all. So, and that we can find all of your heirs, for instance. So it can be quite complex. It's the other mistake people make, is just not even doing anything, not even listing out their assets.
The thing about what you just said right there is one of the reasons I encourage folks to seek a real live human being for their estate planning, because yes, you can make it done. You can do it on LegalZoom or whatever the other ones are, NOLO, I don't even know what they are, but those softwares aren't going to ask you questions, or worse, relay personal stories of situations they've seen with their own very eyes. And I don't, and this is I don't know, it's kind of like one of those things, people spend more money or more time by far on like fantasy football or Facebook arguing politics than they would ever on the stuff that actually matters. And so when I say, well, you got an estate plan, oh yeah, I got the LegalZoom. And I'm like, when did you do it? 15 years ago. And I guess that's better than nothing, but I'll
give you a story about that too. The Forsyth County, Georgia, probate judge has a story on his blog, that tells the story of a guy who did one of those online, or, whatever the disc at the time, probably wills. And that would have been fine. He would have listed all of his heirs who he wanted to get the estate and his tangible personal property. The problem was, when he printed it out, he missed a page.
Ugh.
And he missed the page that had the designated beneficiaries on it. He just didn't print it out completely. It was notarized and signed. Everything else was proper. And the judge said, I would have loved to honor it, but this is the danger of not having, and you know, I know a lot of people say this is really self-serving, a lawyer saying you should get a lawyer.
Right.
But the reason you get a lawyer is we're responsible. If we make a mistake, you sue us later. We made a mistake, you know, but if you make a mistake and your printer doesn't print out the most important page of the will, the judge can't honor that will. And now it's junk. And now it goes by intestacy. By the way, in the state of Georgia, most people think, you know, I think it's common thought that people say, well, if I die without a will, my spouse will take everything. And then after my spouse dies, it will fall to my children. And that's not true. In the state of Georgia, it's equal amongst your children and your spouse. So if I have 2 kids and a spouse, then my estate's going to be split 3 ways. And it's not going to all go to my spouse. So where most people
wait, hold on a second. So in Georgia, if you died intestate, whatever it's called,
without
your
a will,
husband doesn't get everything? Half of it goes to the
Correct.
Kid? Wow.
It'll get split equally between your child and your children and your spouse.
Let me ask you a question on that, Stephanie. So say you're on the deed, all right? So, you know, let's say your husband's Bob. Mm-hmm. We'll say there's Bob and Stephanie are on the deed of the home, and you got $200,000, and then say the house is worth $200,000, and you got $200,000 in a CD that's in your name only. Does the $200,000 house go to Bob, and then the $200,000 CD it gets split up between your 2 kids, or is it? How does that work? You see what I'm saying? Because
Right. So the CD will get split 3 ways.
Okay,
generally.
3 ways.
So
Gotcha.
It's your entire estate. So the house is probably held joint tenants with rights of survivorship. So that would pass to the spouse, right?
Okay.
But most likely that's held if it's held that way. Sometimes one spouse may have acquired the property before they got married.
Exactly.
And it's only in one name. Now that's a more common issue. Is if you have a house that's in one spouse's name and they pass away, now you have the full value of a $200,000 house plus $200,000 in a CD split between your spouse and children instead of as
crazy.
You intended. Yeah. So the spouse thinks, well, that's okay. At least I have the house and some cash to pay the mortgage because I never worked because my spouse worked. But now you don't have that, right? Because now the house is going to might go to your spouse because that's their share, but they won't get any cash. Or potentially, if the house is only in the deceased spouse's name, potentially it would have to be sold so that the cash could break off to a child. Like if you have a child who says, "I want my share," that share is in the house. Get your equity out of that house and give me my share.
Right.
So, and it happens all the time because when people die, money makes people weird. I mean, it really is a dividing factor, and people want their money because, you know, a lot of people have not planned well, and they just, you know, money makes people greedy. Even the smallest things, a grandfather clock could divide an entire family. If you don't put in your will, I want the grandfather clock to go to Susie, right? It could be a very divisive thing.
I can only see if it's a second marriage too. And let's just say you had your home. We'll just say Bob is, you know, your husband, and you know he's your second husband. I'm just using that for an example. And you had your home before you met Bob, and now you die, and so it's just your name on the deed, and you really want Bob to live there, but the kid's like, I never liked Bob to begin with. You see what I'm saying?
Right, because that's my step-parent.
Exactly. So screw him. And if we want to put him out to get our equity in the home. I mean, just
let me ask you. Or what if that house passes to Bob, right? And Bob has the house, and your thought is, well, once Bob has the house because it was joint tenants with rights of survivorship, then if Bob passes away, then it'll go to my children. But guess what? Bob has Bob's own estate plan. So Bob can designate anybody Bob wants. What if Bob remarries? And then all the money goes to Bob's new spouse, and your children get nothing. So that actually is, you know, it informs why a trust is important if you really are in a second marriage situation, or if you think your spouse will get remarried, but you want to make sure that your children to a previous marriage still take.
Exactly.
Or your children still take, because You do not want things to get diluted to the point, and most people's goal, estate planning goal, is to make sure that they leave something for their children, let's say. If that's your goal, then you need to really think about a trust structure, perhaps, right? And every situation is different. But that's where we see a lot of people really, really thinking about the importance of, say, a trust over just a will-based plan. And same thing with business owners. You know, they may want their business to follow a certain way and hold those assets in trust. But I think people are a little afraid of trusts because they don't understand them. But really, in your lifetime, a trust is just you. It's your social security number.
Yeah.
What a trust does is retitle your assets into this vessel, into like a bucket, this trust bucket. You can change the terms during your lifetime, but when you pass away, it then falls outside of your estate, outside of the probate process, no court, right? If you've funded it fully, and then it falls down to your heirs the way you have selected it to fall. And then all of these things like remarriages and everything, sometimes creditor protections if it falls into an irrevocable trust, those things come into play, and those things are really critical to preserving your legacy for your children.
Is Florida with intestate, is that the same thing as Georgia, or is that because you practice law in Florida too, right?
Well, I'm a Georgia attorney. I'm a Georgia and New York attorney. So Florida intestate. Yeah, I don't do estate planning in Florida.
But you have office down there, right?
Yeah, there we only do immigration law.
Okay,
so we only do federal law there. Mm-hmm.
How
we
about
have Florida
New York?
lawyers down there, but
okay.
In New York, we have a basically virtual practice for New York. So we help some New Yorkers, but through our virtual practice.
Is the intestate in New York similar to Georgia?
No. The surviving spouse let me answer your question. Florida, can't give Florida legal advice.
Understood.
But, intestacy is different in Florida, so the entire estate would go to the surviving spouse, for instance.
Okay.
New York is a little different because New York actually allows for a marital share. So there's a portion of the estate that the spouse will automatically get. We just don't have that in Georgia.
Okay. But and this is the kind of stuff where, look, how would I get LegalZoom and stuff? And I'm not here to freaking, make sure that everyone hires Stephanie. I'm saying, how could LegalZoom know who you are if you're in? I literally, as we're talking, I got an email from a lady who just relocated from Maine to Asheville, North Carolina. And it's just like, and she's asking me, hey, do I know any attorneys or CPAs down there? Which is good, because I always say be proactive.
Yeah, you should talk to someone. Yeah.
But the issue is, if you are LegalZoom and you did the thing in New York, and now you're coming to Georgia, and you're like, I said, you have a will, and you're like, yeah. Well, if you didn't tell me that you relocated, it might not work the way you think it did, because where you had drawn it up change is different now than down here in Georgia. You know what I'm saying, Stephanie?
Right, exactly. And most of the time that a will is going to be honored when you move, but you absolutely, when you move, you want to check in with a local
exactly
attorney, and just get it updated. It's not that expensive, and it's so important to just have everything updated. And not only that, in our practice, we really believe in making sure that we speak to a client at least every 2 years, get an update on their life. Life changes. If you have a 20-year-old will and the beneficiaries are no longer, let's say the beneficiary has grown up, was a minor child, and now that beneficiary has grown up and they like to spend a lot of money. Now, are you still thinking that you want to give them outright a $500,000 estate, right? Or larger in some cases? Maybe they can't manage their money and you want to help them through another vessel, or maybe just simply they're no longer living. Some beneficiaries may no longer be living. It is important, no matter where you're living. Certainly if you relocate, you need to talk to an attorney, a local attorney, and have them just evaluate your will and maybe update it. But every 2 years, just reach out. If you have an attorney that drafted your will, for us, we just do it. We do it as a matter of practice, free. We always, every 2 years, we look at the person's circumstances and their goals and make sure it still aligns with their estate plan. But just reach out to an attorney every couple of years and get that will updated. read it yourself. Some people haven't taken their will out for 15 years and looked at it, and they don't even know what's in it. The other mistake is, of course,
I do. When people got living trust, they'll say, who's your successor trustee? And, someone has a trust usually knows a little bit more than someone just has the will in terms of what their estate planning is, because they got the trust for a specific reason, and no one knows. And I said, that's fine. You don't have to know. Let's bust it out. And then we'll bust out the trust. And we'll say the successor trustee is Uncle, we'll call him Uncle Jim. But Uncle Jim's got dementia now. I said, yeah, we probably need to update that, because if something were to happen and your Uncle Jim's co-trust or successor trustee, that ain't going to fly. You know what I'm saying? Didn't Georgia, like 10 years ago, change our laws for medical powers of attorney or something like that? What I know, Florida changed it, and Georgia. Both these states had some change in estate planning, in the last 10 years or so. Are you familiar with that by chance?
Yeah, we have a in Georgia we have a statutory advance directive for healthcare.
Yeah.
Real easy form, just designating somebody who is going to, be able to make decisions for you if you're incapacitated. Very fairly simple. But you have to do it, right? And you have to execute it properly. But it's available on a lot of websites. A lot of people will use those websites, but certainly we try to do it, in combination with your comprehensive estate plan. But it's called Advanced Directive for Healthcare. That was the change, and they updated the statutory form.
Yeah, but see what I'm saying? It's like with LegalZoom, I just feel like folks, I'm not trying to come across like a sales pitch. I'm telling you, LegalZoom is not going to reach out to you and say, hey, by the way, the laws have changed. And because Florida has something pretty significant too. And then, just going back to New York State, they just updated their estate tax law, the state estate tax law.
Right.
And no one's going to reach out to you from a computer program and say, hey, you got this money that's going to be subject to XYZ estate tax, XYZ in Pennsylvania. We got inheritance tax. New Jersey just had massive changes to their estate tax law, but they still have inheritance tax. No LegalZoom is going to talk to you. Now, with that said, Stephanie, I got to tell you, just because you hire an attorney to draw it up doesn't mean that attorney's as competent as like Stephanie would be here. Because I'll give you an example. I had these folks in South Jersey when I was working at Philly, and she thought she had set. And back then, New Jersey, you only had $675 that you could transfer without subject to the New Jersey estate tax. And this is only probably 8 years ago. Long story short, they thought they had an irrevocable trust set up, to avoid the estate tax. And if you looked at the first page of the flipping trust, it said this trust can be revoked by the grantor, and the grantor was them. And they had an attorney draw that up, and that is like it's kind of like in financial planning. We got a lot of bad financial planners out there. We have some good ones. We have a lot of bad ones, and unfortunately, the same thing goes to law. So somebody says, "Well, I don't trust any of those guys anyway," and it's just too bad because there are a lot of good attorneys out there. There are a lot of good financial planners, and if to throw them all in with some of these incompetent fools is, I just think it's putting yourself at, not you, Stephanie, but the listener here, at undue risk for sure. That's too bad.
Yeah, absolutely. I mean, that's the whole goal behind a revocable living trust is that you can revoke it, you can change the terms, and you can update it as you need to, because your needs are going to change throughout your lifetime.
Do you help so the big thing is an unfunded trust, and I've seen this a million times a Sunday, and that ticks me off. So someone comes to Stephanie's office and says, and you have the discussion and you find a trust is valid. Obviously, folks, if you're going to do a trust with an estate planning attorney, it's going to be a little bit more expensive. No getting around that, and just recognize that's the thing. I mean, literally, it's if you talk to a competent estate planning attorney who recommends a trust, a living trust, all right? And we talked about living trust before many times. We'll do it again. But that just is literally just you own it, you control it, the whole thing. It flows back to your 1040. It's part of your estate when you die. But if you go into Stephanie and she says, hey, I recommend a living trust because of whatever it is, and obviously she'll tell you why. Do you help them, put the assets in the trust, Stephanie, or what? I mean, because that can be a big problem with these unfunded trusts, I've found.
Yeah, we started the conversation talking about mistakes with estate planning. That's another huge mistake, is having either a trust that's not funded at all, or that is partially funded.
Yeah.
Because you have to fund a trust is useless if it's not funded. And by funding, all we mean is you're changing the title of the assets into the name of the revocable living trust. The Stephanie Scarborough Revocable Living Trust, my assets are now owned in that name. And that's what we do. And it's going to happen at your death, I should say. Somebody has to run around and do all of this. You're just doing it in advance, right? And we do help people do that. We give people the option if they want us to do it. Obviously, they pay us to do it. Yep. But we do give them the option. If they want to do a self-funded trust, then we're probably going to harass them almost. And we're going to call them and make sure they funded that trust. We have an asset and liability spreadsheet that we give them where they can mark off what's been funded, and then we want to check back with them.
Oh, okay.
Sometimes
cool.
It takes them 2 or 3 months, but we want to see, hey, send us your updated spreadsheet.
That's fantastic.
Tell us what you funded into the name of the trust. And then we also want them to put that into their binder, the deeds or the bank statements and everything that they've transferred into the trust into the binder, so that when we do meet with them in a year or two, depending on their circumstances, then we can see what's been funded.
Yeah.
And we can make recommendations. Even if they don't pay us to fund it, we want to follow up and make sure it is funded. And I can tell you, I have clients who haven't funded their trust, and they've come back to me because they didn't want to pay extra money. It's a lot of running around. It really is. For people who own a substantial amount of assets, there's a lot of work to be done, mostly administrative work. So we've had people who just couldn't get everything funded and just came back to us after 6 months or so and said, "Can I just pay you guys to do this?
Right.
Just do it." Right. And